Hello, everyone. Just issuing a 30-second warning to get comfortable. All right. I propose that we begin now, so if everyone could please take their seats, put their phones on silent. We're going to get started. Should I just kick off? All right. Thank you all for joining us today at our session on utilising the law as a key tool to address climate change and promote equity. This event is co-hosted by the International Bar Association, the American Bar Association, the Law Society of England and Wales, and the Order of Attorneys of Brazil, OAB, also known as the Brazilian Bar Association. My name is Lara Douvartzidis, and I am a lawyer at the International Bar Association, and I sit within the Legal Policy and Research Unit. Prior to that, I practiced as a solicitor in environment and planning law at a commercial firm in Sydney, Australia, which is where I hail from, if you hadn't already noticed. It's a pinch me moment being here with all of you, and I want to thank you all for attending. There is an expansive list of critical climate issues facing us all. My home country, Australia, endured devastating bushfires in 2019 and 2020. Our Great Barrier Reef is dying, and that's not my opinion, that's just a scientific fact. And the oldest living culture on Earth of 60,000 years plus, our Aboriginal and Torres Strait Islander people, are not recognised in the Constitution yet. Elsewhere, there are similar tales. Biomass in South America is being cleared at a rate that is alarming. Sea level rise is claiming small island nations for their own. Oceans are dying from acidification and temperature rise. There are devastating floods in each continent. There's drought, fire, flood, food wastage, fast fashion, scope 3, forced displacement, the list of critical issues goes on. In each circumstance, lawyers are there, whether it's proposing legislative reform or responding to government issue papers, being the levers in brokering deals, drafting contracts, erecting tax structures, advising on risk at the request of in-house counsel, filing injunctions, commencing proceedings, framing legal arguments, undergoing origination work for class actions based on factual circumstances that don't pass the sniff test. A pledge was made at Glasgow's COP26 to increase capacity of climate lawyers, specialised capacity from 600 to 6,000 lawyers by 2024. So we are here to answer that. And there's 4 of us here, and as far as I'm aware, we're the only bar associations here, but we'd really love to see more. We're committed to assisting this pledge. We're here to help, be of use, de-silo, cut across jurisdictions and policy, and connect capacity with need at a local and global level. It's time for lawyers globally to consider taking up the mantle that other professions have felt the weight of for so long. So, to the scientists who made moves in this space to track what others couldn't, and who had to repackage their profession to people that felt it wasn't important. To the journalists who broke stories in this space despite fear of retribution, to the people in finance who make money flow and are doing the right thing to get money to where it needs to be on the ground to help with these immense challenges, and to environmental defenders who risk their lives every day, and to policymakers who grind day in, day out to make this world a better and fairer place, despite how hard it is and despite the laws that exist in each place. And I want to say particularly to us youth who have to live with decisions that other people make, and the decisions affect our lives more than theirs, because we'll be here when you're gone. Scientists aren't behind every closed door, but chances are a lawyer is. So thank you to the lawyers that act for clients who face difficulty or needing a justification, if all they're doing is upholding professional duties, and that expands to all people in this space. So to all lawyers everywhere who work hard, thank you. But lawyers are not politicians. Governments, no matter how hard we depend on them, answer to a different call. Our call as lawyers is to the rule of law, justice, and our utmost duty is to the court. For every lawyer on this earth, that is generally our north, in many jurisdictions, our duty to the client is secondary, and the rule of law demands that order. Appropriate assessment of risk is what lawyers do. And to do it effectively, it must be done on the best available knowledge. And that means the best available science. As John Kerry said last year, every lawyer is a climate lawyer now. Approaching the task ahead by understanding this, coupled with greater incorporation and appreciation of Indigenous technical knowledge and sensitivities of jurisdictional differences, is the best way forward to implement and execute our duties as officers of the court effectively, and to fulfill our professional obligations to the court and to our clients, to represent their interests and assist in making sound decisions and capitalise on opportunities in the transition to a green economy. The rule of law depends on it. However, lawyers are not there to cast moral judgment on clients. That's not our job. That's not to say that solicitors can't open businesses to practice law in a way that is aligned with a cause. Those lawyers are also essential. But for us all, we're bound by ethical duties based on the laws of our jurisdictions to discharge those duties. But we may fall foul of ethical duties if we give advice that is contrary to our client's best interests and which has an incorrect factual basis. For example, conceptualizing risks of a project, particularly in circumstances where climate litigation was brought. And I'm thinking here of the Neubauer case against Germany that culminated in lawmakers passing a bill which approved adapted climate litigation that requires, at a minimum, reduction of 65% in greenhouse gases from 1990 levels by 2030, which has been effective since August 2021. Lawyers should be climate literate and understand the context in which we give our advice, because that is necessary to the assessment of risk, and that means understanding the Paris Agreement and the Paris Rulebook. Knowledge is key to our future, and that means two things: knowledge of the best available science and knowledge of laws and duties of each jurisdiction, because no two jurisdictions are identical. To understand our past and future simultaneously, we need to do that from the people that know best. I'm reminded of my friend Mark Fennells, KC, Chair of the Bar Council of England and Wales, on the United Nations Basic Principles on the Role of Lawyers. It states that lawyers should not be identified with their clients or their clients' causes as a result of discharging their functions. It also states that professional associations of lawyers shall cooperate with governments to ensure that everyone has effective and equal access to legal services, and that lawyers are able, without improper interference, to counsel and assist their clients in accordance with the law and recognise professional standards and ethics. I am, and we are, optimistic that the law can rise to meet these challenges, and with increased capacity of all lawyers to become client literate, with leadership from bar associations and law societies, we can get to where we need to be together. And to assist with this balanced conversation, we have 4 panelists here who it is my privilege to introduce. To my left is Professor Dr. Marie-Claire Cordonier Segger, and she is a Leverhulme Trust Visiting Professor at the University of Cambridge, Senior Director of the Centre for International Sustainable Development Law in Montreal, Canada, Executive Secretary of the Climate Law and Governance Initiative for United Nations Framework on Climate Change, and a full Professor of International Law from the University of Waterloo in Waterloo, Canada. She's a Law Fellow and Director of Studies for the LLM MCL at Lucy Cavendish College, University of Cambridge, a Fellow of the Royal Society of Canada and Laureate of the Wiramanti International Justice Award, and she has published over 25 books and 180 papers on law, justice, climate change, and sustainable development. To her left is Roger Martella. He's the Chief Sustainability Officer of General Electric Company. Among many important worldwide responsibilities inside the company, he coordinates the operation to give a comprehensive and cohesive sustainability approach to GE initiatives. Roger has co-authored and edited 4 books on the intersections of ESG, climate change law, international environmental law, and human rights. And he's also an officer of the IBA. To my right is Letícia Perrone Campos Mello, and she's the head partner of ESG and climate at World Law Firm, Brazil, and the representative of the OIB at COP26 and 27. She has over 15 years of progressively responsible experience as senior legal counsel and partner, and she's led teams and outside counsel in first chair disputes, complex arbitration and litigation matters, as well as in contractual matters on behalf of major international and Brazilian corporations. Throughout her career as lawyer at a tier 1 legal firm in Brazil and Europe, she's built a solid success in managing strategic and high-profile cases in real estate, infrastructure, and trade finance sectors. To her right is Selina Lee-Andersen, who is a partner in the Vancouver office of McCarthy Tétrault LLP. I apologize if I pronounce that incorrectly. And she's a member of the firm's Environment, Regulatory, and Aboriginal group. Recognized for her in-depth knowledge and range of experience, her practice focuses on the areas of environmental law, corporate and commercial law, regulatory law, compliance, and, this is not correct, environmental law, regulatory law, and Aboriginal issues in the energy and natural resource sectors. Selina's practice specializes in climate change law, where she provides strategic, innovative advice to clients on matters relating to carbon pricing. She is the immediate past chair of the Canadian Bar Association's National Environmental, Energy and Resources Law section. So, to kick us off, we'll go to Roger, because he is very in demand at this Blue Zone and at COP. So, Roger, what are the largest challenges in your organisation with respect to sustainability, and how have lawyers assisted in these challenges, and what would you like to see more of in your capacity as IBA officer and Chief Sustainability Officer at your work?
Well, Laura, thank you very much for the introduction. And I just want to take a minute, if I can, from my time to congratulate you personally and the bar associations for being here. This was something that everyone had to work very hard and strategically over, not me, the rest of you had to work very hard and strategically over the last year to earn. And for those who are maybe not physically with us but calling in, we're sitting in a room in a blue zone, in the blue zone of the COP27 in Sharm el-Sheikh. Probably having done 50 meetings in 5 days, probably the nicest room I've been in. So that alone says a lot, the most comfortable room for sure. But it's a reflection on how strategic these global organizations have been in being united as one force. These multiple law associations, I won't go through all of them, but a very diverse mix of law associations globally. And then you really focusing on the logistics to make this all happen, to get here. It did not come naturally. So you had to earn this, and you've done it, and so congratulations on that, and it's great precedent for the future. As someone who believes very much about the role of the lawyer and the law in addressing these issues. So thank you for the question, and maybe I should first address what's on everybody's mind, like, why am I even here? I'm the person who works for the company. You asked me a question about equity and things like that, so maybe I could just step back for a second on why am I here, and why are companies, even having the opportunity to be on the stage with you. And you may have heard, if you've been at COP27, whether it's from John Kerry or others, that one of the themes that's coming through, which I think is a very positive one, Glasgow also, it was talked about, but I think more in force here, is how companies are increasingly part of the solution in addressing some of the world's biggest challenges, and that includes climate change and a just energy transition. So we're honored, and we take it with a lot of humility. The invitation to be part of this wasn't always the case, where we were more on the sidelines. And we take that really seriously. And to your point about equity, I want to just address that too. GE is a 130-year-old company. We were founded by Thomas Edison. And we've changed a lot, and we're changing right now over those 130 years. But we've always had one theme that's united us for 130 years, and that is that we would always innovate technology to lift up the quality of life for people all around the world. So today, that's never been more important than it ever has been in our past. We're focused from the climate change, energy transition, on the Sustainable Development Goals, and making sure that we can help innovate technology needed to decarbonize the energy sector, to make transportation and aviation more sustainable, and to make healthcare more accessible for the half of the world's population that lacks access, but do it in ways that also improves access to affordable, reliable, and sustainable electricity. 750 million people in the world can't turn the lights on to do their homework or access jobs or access healthcare. And so as we decarbonize the energy sector through innovation and technology, we want to grow that access so that everybody has that ability to prosper. Everybody has that ability for a high quality of life and for those same wonderful opportunities. So that's what we're committed to. That's our legacy, and that's how we approach the equity issue. And I think to the direct point of your question in terms of what are some of the challenges we're facing? I'll just come out and say that our challenges are not primarily legal, but lawyers have a real role to play in helping us address those challenges. Our challenges are operational. We have made sustainability commitments, as have many other companies here. We're always trying to improve them, make them better, but we have to deliver on those commitments. That's job number one. If we say we're going to do something, we want to do it, and we're very careful in what we say. When we say it, we want to be credible, and we want to have some line of sight. So we have to deliver on those commitments. And we take our ESG commitments, our climate change commitments, with the same responsibility that we do our business commitments. Just like we have to perform for our shareholders, we have to perform for our ESG commitments. And that means operationalizing sustainability just as we operationalize our businesses. So that's not first and foremost the legal role. But lawyers have a huge role to play in the success of our business, and they have a huge role to play in the success of our sustainability commitments. Because when you're looking at how is a company doing for sustainability, the first question you should ask is this a well-run company? If the company is not a well-run company, you should be very suspect about whether they're going to really achieve those sustainability goals. If they're a well-run company, you can be more optimistic. And lawyers play a critical role into whether a company is well-run and whether it can help achieve its goals. So we look to kind of strong lawyers who can help us on employment issues, on diversity, inclusion, compliance, litigation, human rights, cybersecurity, safety, environmental issues. And we look to people who are just really good lawyers to help us succeed, because if they can help us succeed for the company, they're going to help us succeed on our sustainability goals. And these two things are increasingly becoming one and the same: how we align running a business as a business, and how do we align that with our sustainability goals, with the equity goals that we spoke about earlier. And I'll give you an example kind of ripped from the headlines today, because it really dawned on me. Was I had an opportunity a few hours ago to visit the power plant that keeps these lights running and the air conditioning going, the Sharm el-Sheikh power plant. And it's about 15 minutes from here, amazing facility. And so on Monday, we're going to do something super cool. We're gonna run the power plant on a blend of hydrogen for the first time on the African continent. And I'd love to tell you all about the logistics of how we got the hydrogen, how we got the truck from Kuwait, the hydrogen from Cairo, how we brought in technology from New York and all these other places in the world to do this for the first time, not only for Egypt, for the African continent. And we're doing that very intentionally because we want to send a message that it's not only the US and the EU that should be invested in emerging technologies like hydrogen. It should be emerging economies in places like Egypt and Africa that should have this investment as well. So it's going to be something we're really proud of. So if you're here on Monday, at some point during the day, some percentage of your electricity will be provided by clean hydrogen blend. But the reason that's relevant today is I'm walking around and they showed me everything, but they hadn't shown me the trucks. There's 3 trucks with like 10 canisters of hydrogen that came from Kuwait through Cairo to here. I'm like, I want to see the trucks. So he's walking me over. He's like, yeah, we had to put the trucks over here. It's very secure. We've got security on all these safety, a lot of safety issues with hydrogen. He goes, and of course we had to have all the lawyers read all the documents, and it took a little time, and they cleared all this. And just really reinforced to me something that we see clearly as a technological engineering accomplishment and operational accomplishment. He doesn't know I'm a lawyer. He went out of his way to bring up his partnerships with the lawyers, how some transactional lawyer or some contract lawyer or some safety lawyer helped make this possible, and without that we never would have gotten the trucks there. And I thought it was a really good proof point for my theme that when we talk about the role in the law in helping companies succeed, we need really good lawyers like that that'll help us do that. So looking, and I think to the last part of your question, Laura, in terms of where can the IBA and bar associations play, this is my blunt and honest recommendation here as an officer of the IBA. We need more training for lawyers who are good lawyers to succeed in this space. I need less training on ESG lawyers. I need less ESG practice groups. I need less law firms marketing me on ESG. I need lawyers who are employment lawyers who understand the impacts of ESG. I need transactional lawyers who help my friend with the truck today who understand the importance of that project. I need human rights lawyers. I need governance and security lawyers who understand disclosure requirements. So my recommendation would be where the bar associations can focus, where law firms can focus, is taking people who are good lawyers and helping develop that specialty in the issues that matter to this space, as opposed to trying to create ground-up ESG lawyers, where I think there's very limited need, but much higher demand for good lawyers who can understand this area.
So if I understand that right, you'd like to see top-of-the-class lawyers that are climate and human rights literate, that understand, I guess, the everyday challenges that we face, that are scientifically literate, to give the best possible advice to you. Is that what you think? I think
that's right. I mean, take the example, like one hot topic right now is disclosures, right? And so any company is going to have a team of lawyers who are focused on filing disclosures with the SEC, filing disclosures with the European Union, and we're going to rely on outside law firms to help us strategize over those disclosures. I have a big demand for security lawyers who can help me understand the uniqueness of SEC reporting requirements when it comes to ESG, the European Corporate Social Responsibility Directive and the European due diligence rule. That doesn't need to be an ESG trained lawyer, but what I need is a really good lawyer who understands disclosure, who also can translate that into the sustainability space and has developed that kind of specialization. And I think that's true for even for litigation, that's true for each kind of practice area. We need that specialization on ESG from the other types of practice areas.
I think that's right. And just quickly before you have to go, what do you make of the letter that went out from 5 Republican senators in the US to 51 law firms about concerns of antitrust issues with ESG? That idea that, that people from government or the legislature or the executive trying or encroaching on how law firms run their businesses. What are your thoughts on that as an in-house?
I haven't had time to read a lot of letters this week. I've maybe seen a couple headlines. I'm aware that there's some, like many things in life, things come up and down, and there's, momentum and there's pushback. Right now we're entering a phase of maybe more pushback on ESG. Has it swung too far? These are legitimate conversations to have. I think what I would say to someone who is maybe on the skeptical side about ESG or companies going too far, you talked about being a younger generation, right? And I think that's a really important point. Let me talk about who cares about this. First and foremost, our employees. Whether or not someone writes a letter saying they think this is important or not, our employees think this is important, particularly our younger employees. This is a huge source of recruitment and retention. If we're not doing this right, our employees are just simply not going to work with us. So that's number one. So if they can write a letter to our employees maybe, but I'm not sure they're going to be too sympathetic. The second are our investors. Our investors are increasingly making decisions on how they prioritize where they put their money based on the sustainability performance of a company. And the third are our customers. And our customers are increasingly deciding, in the past we might have, assigned 50% of your rating to cost, 50% of your rating to your product and quality and performance. Now we're going to dedicate 20% of that to your sustainability performance. So I don't have a view on whether law firms and antitrust, I'm not an antitrust lawyer and all that, but to someone who might be more skeptical here, I think that's my response is we have to be thinking about our stakeholders in addition to trying to do good on these issues, and those stakeholders are expecting this of us, and that is a trend that is not going away.
Thank you so much. We really appreciate you taking the time. Now, if I switch over from global north to global south, Letícia, with your experience in Brazil and internationally, can you explain the role of OAB and how it's different from other bar associations? and also how you think the OAB can contribute to climate mitigation and adaptation in Brazil, but internationally.
Thank you, Lara. Thank you. Hello, everyone. Well, we are here today at COP27 because we know that humanity has no great future if we continue with the same system of production and consumption with the high carbon inputs. In other words, if politics and business continue as usual, we will pass the tipping point. Climate stability and justice are without a doubt a very important mission that connect us all here. As I heard Stefan Hobenheimer, director of FILE Foundation, says, to change the system, we need to co-produce knowledge with all actors of society, government, academics, experts, civil society, companies, and consumers. Society changed when people learn, and everyone knows that learning increases with motivating factors. And this is where lawyers can have a special role. We lawyers and bar associations, we are also actors in this change. And we must use all our efforts, legal skills, and training to co-produce with the other actors in society the knowledge and motivating factors to contribute to this important fight for climate stability and especially for justice for the most vulnerable people affected by climate change. One of many, for a long time, high emissions activities were part of the business. It was the name of the game. But we are facing a turning point in our history across the world. We see a boom of litigations and complaints aiming to hold the most responsible for the climate crisis accountable or demanding more action. There are more than 2,000 climate litigations cases worldwide. And this is affecting companies' behaviors, policies, states, and our daily life as legal practitioners. As lawyers, we know well that when parties are not able to settle or agree about something, that justice is there to decide. We also know that justice was needed in many cases where the interests at stake were of minorities, or to avoid unfair policies of majorities or of stronger players. So my question is, do we have time to keep waiting for more laws or agreements? Science says no. The organization that I represent is the National Brazilian Bar Association, also known as OAB, the Order of Attorney of Brazil. We have 1.2 million lawyers as members, and we have important prerogatives stated in the Brazilian Constitution. Throughout its long history, OAB has had a constitutional role in our society of protecting the democratic rule of law as well as human rights. The entity has several tools at its disposal to implement this prerogative, including the legitimacy to file direct actions in the Supreme Court of Brazil to discuss the unconstitutionality of primary and secondary laws, plus several other collective actions. The Statute of OAB, which is a federal law, states that OAB has the goal to defend the Constitution, the legal order of the democratic state of law, human rights, social justice, and to fight for the good application of the law, for the swift administration of justice, and the improvement of the culture and legal institution. The Brazilian Bar Association Code of Ethics determines that lawyers should be aware that the law is a means of mitigating inequalities in order to find fair solutions, and also that the law is an instrument to guarantee equality for all. To us, all means all, not just some. The best available science, the news headlines, and common sense dictates that the climate crisis is a matter of social justice, as climate change disproportionately impacts people who are already in a situation of vulnerability, increasing social inequalities, especially in the global south. In that regard, the human right to a healthy environment is a fundamental right to a life with dignity and well-being. Climate change is one of the most pressing and serious threats to the enjoyment of all human rights. Considering this framework, the UN, in a historical resolution, recently recognized the access to a clean, healthy, and sustainable environment as a universal human right. But we lawyers in South America, we already knew this. The Brazilian Constitution of 1988 has stated that the right to an ecologically balanced environment is a constitutional matter. Our Constitution imposes on the state and society the duty to defend and protect the environment for present and future generations. And we are not alone. Colombia, Ecuador, and more have such constitutional protections for the rights of nature. Within the development of environmental law in the past 40 years, the high courts in Brazil have given interpretation that supports the protection of the environment and the human rights associated with it, contributing to the improvement of the Brazilian environmental protection system. Recently, the Brazilian Supreme Court handed down a world decision to issue a precedent that has equated international environmental treaties, including the Paris Agreement, with human rights treaties, granting the Paris Agreement super legal status in the Brazilian legal system. In other words, the Paris Agreement is above all ordinary laws and regulations in Brazil, serving as a parameter for their interpretation and implementation. We hope that this important precedent will be followed by more climate action in Brazil and as a precedent and inspiration for other jurisdictions to fight for using their domestic legal system to achieve a similar outcome. Climate change is one of the most challenging issues of our generation. We must then act with all the tools that are at our disposal as a duty to the next generation and to help those who are the most vulnerable. Lawyers can act as important actors to motivate change in the system. Let's remember that all relevant business transactions in the world demand contracts, and lawyers are there to give counsel to negotiate and draft them, so we can do this in a way that is climate conscious. All lawyers, no matter their vested interest towards or away from climate action, should properly and realistically advise their clients with respect to climate risk in an organization's operations and supply chains, as failing to do so may cause harm to the client financially and in its reputation. This event is an important, unique initiative because for the first time, different bar associations are banding together to provide awareness and capacity building for law firms and lawyers all over the world about climate law and climate justice. As OAB President, Mr. Simonet says, we must act cooperatively, exchanging ideas, strategies, and efforts to fight climate change globally and locally. We are actors to help change the system, and because of our professional training, we hold important motivating factors and tools to speed up the process by bringing cases to justice and also bring awareness of the importance of lawyers fulfilling their mission in their everyday work assisting clients and governments all over the world. OAB wants to work in cooperation, and we are honored to share a bit of our mission in this important forum. Thank you very much.
Thank you so much, Letícia. And just picking up on what you were talking about legal tools, I just want to impress upon all of you that's watching that, you know, us lawyers, we have different tools in our toolbox or different ingredients in the pantry depending on which jurisdiction you're from. There are jurisdictional quirks and constitutions differ. Civil and common law jurisdictions are different fault lines, but make no mistake, similar structures can be built and similar cakes can be baked, if you want to think of it that way. And it's my belief that we're better for studying laws elsewhere to learn, to understand, to challenge, distinguish, to amend, and on this, it's my belief that every lawyer in the world would be better studying constitutional law and legal precedent from South American nations in addition to their own, and particularly the Inter-American system, the Inter-American Court and Inter-American Commission of Human Rights, because at least in my case, I undertook a comparative analysis for my master's thesis on the meaning of the legal term free, prior, and informed consent. And I look at Colombian constitutional law, OAS law, UN principles in North America, as well as looking at my own laws in Australia to draw out lessons. And guess what? South American laws were an inspiration. So I just wanted to give credit to them because they deserve recognition for that. And on that, I'm just going to move now to Selina. Your practice, sorry, I have to turn this way. Your practice focuses primarily in the areas of environmental law, corporate and commercial law, regulatory law, compliance, and Aboriginal issues in the energy and natural resources sectors. So, as a Canadian-trained lawyer, how has your practice area shifted over time, particularly with respect to reconciliation with Aboriginal peoples? And what is the Canadian Bar Association doing with respect to climate policy and climate commitments as an organisation?
Thanks, Lara. I just wanted to echo Leticia's, highlighting the importance of global collaboration, and appreciate the opportunity to, to be here on behalf of the Canadian Bar Association and to engage in this important discussion. Just in terms of my own practice, so my own experience with Aboriginal law goes back about almost 15 years with the proliferation of First Nation partnerships in clean energy sector in British Columbia, which is my home jurisdiction. Since then, my practice has evolved from drafting what we call impact and benefit agreements, which are agreements between project developers and First Nation communities to help build capacity in those communities, as well as to bring economic benefits to those communities. These are types of agreements that are, I think, unique to Canada. They started sort of developing early days up in the mining sector in northern Canada, but now they are really a de facto way of doing business and helping to advance reconciliation. But since those days, I've seen that First Nations have, instead of just being passive participants in project development, that they in fact want to be owners in a business and to build capacity in their communities to have skill sets so that they can run these businesses. So to really establish business partnerships and to be partners in the truest sense of the word. So this reflects, I think, a desire of Aboriginal groups to just sort of move away from just sort of simply observing projects and commenting on projects to actually having input into projects. So these relationship building efforts are also helping to advance reconciliation between Aboriginal and non-Aboriginal communities across Canada. Just by way of background, you mentioned that in Australia, Aboriginal rights are not protected under the Constitution, but in Canada, we do protect the Aboriginal rights and title of our First Nations, Inuit, and Métis people. So over the course of the last 25 years, there's been a very dynamic body of case law that has developed from our Supreme Court of Canada to give to protect certain rights and to ensure that there is meaningful engagement with First Nation groups and other Aboriginal communities on issues around consent and around resource development projects, because as you know, Canada is a resource-rich nation, just like Australia is. Just by way of, just in terms of the reconciliation piece, for those of you who aren't familiar with our history, we have started down a path of reconciliation because over our sort of colonial history, we had an Indian residential school system in which young children from Aboriginal communities were taken from their families and sent to schools to be, Canadianized. So this left quite a scar and a legacy of trauma. And so in 2007, our federal government and Aboriginal communities entered into a truth and reconciliation exercise under a residential school settlement agreement. And this agreement called for the establishment of the Truth and Reconciliation Commission, who actually gave the opportunity to Aboriginal people across the country to come and share their experiences in the residential school system. So that was a way to sort of help them on the path to healing. In 2015, the Truth and Reconciliation, after hearing hundreds of thousands of hours of testimony from Aboriginal community members, completed a report. And accompanying this report were 94 calls to action. So we call these the TRC, the Truth and Reconciliation Commission Calls to Action. So these calls to action span a whole range of issues, social issues, cultural issues, educational and justice issues. And there's even a specific issue, a specific call to action, number 92, which calls on the corporate sector in Canada to adopt the UN Declaration on the Rights of Indigenous People as a framework of reconciliation in the business sector. So most of my clients are project developers and in the business sector. So we work together with First Nation communities to build projects and bring benefits to those communities. So there is a very important role for us lawyers to help advise on not only these types of commercial arrangements, but also the types of risks, whether they're litigation or other types of risk associated with the land base, and helping our clients to secure certainty around the land base. We have a very sort of difficult conversation around consent, and because it's sort of tied with our notion of a duty to consult. So this is kind of an ongoing discussion that we are taking place, but these types of agreements are seen as good sort of indicators that a community has essentially sort of been meaningfully consulted and are ready to proceed with a project. I also wanted to note that the UN Declaration on the Rights of Indigenous People we have at the federal level and in British Columbia legislation that is looking to implement the UN Declaration. And so we are looking at laws. So there is an order from the senior sort of government officials to kind of have each ministry and each agency review their laws with a view to making sure that they are consistent with the UN Declaration on the Rights of Indigenous People. This will take a number of years, but it's a very positive step, and I think it's important for Indigenous communities to see that these steps are being taken. In terms of the CBA itself, the Canadian Bar Association has a long history of urging government agencies and other groups to take action on a range of environmental issues, including climate change. One of the early resolutions dates back to 2001, when the CBA passed a resolution urging governments to implement international environmental agreements. In 2011, there was a resolution urging action on implementing mandatory greenhouse gas emission reductions, as well as implementing carbon pricing. In 2019, the CBA, together with some of the other G7 Bar Association heads, agreed on proposals on different matters, including meaningful discussion around safeguarding the environment, as well as the climate for current and future generations. In 2020, there was some members of CBA who brought forward a resolution which wanted to kind of establish a definition for climate justice and to encourage lawyers to do pro bono activities, as well as incorporate climate change considerations into law reform submissions. For various reasons, this resolution did not pass, but we are still engaged in the conversation, and it's a very important one that we're going down.
Thank you very much for explaining that, and particularly explaining your role in the road to reconciliation in Canada. And I think that's important because we talk about how climate change is a forward-looking matter, which is absolutely true, but it's also about our past. It's about our deep past as a planet, and particularly the past of our Aboriginal and Torres Strait Islander people, our Indigenous and First Nations people across the world, and understandings of cycles of nature, and who have had a history of suffering unjust laws. And always was, always will be. The UN and other international bodies have confirmed that climate rights are human rights, which includes the right to self-determination, the right to life, and the right to culture, which form the basis of disputes around the world under different mediums, as I said, using different tools in the toolkit. But it's a common trend and something that, us lawyers need to be continuously talking about. So moving now to my left, this is Marie-Claire, as I said. Fun fact, she leads the climate law and governance initiatives during COPs since its inception in Montreal COP11 in 2005. She was at Rio at the Earth Summit in 1992, working on the UNFCCC text itself. She's the OG. Like, she's been here for a long time, and she's amazing. And just a total fan, if you can't tell. At COP26 in Glasgow, I should say, sorry, you announced the Climate Law and Governance Pledge, which is to increase capacity of climate lawyers, the specialisation from 600 to 6,000 specialists by 2024. Can you please tell us about this incredible target? What's needed from lawyers? What's needed from us? And if you had one wish, what you'd see in this space?
Thank you very much, Lara. And I'd like to especially recognize and honor here in this room, since you're speaking of the Climate Law and Governance Initiative, two of the winners of the Global Leadership Awards, Climate Law and Governance, who are sitting in the corner quietly, one of whom could have probably given the best answer in the world on the antitrust case, Wendy Miles, KC, who led the creation of the Net Zero Lawyers Alliance during the Glasgow Summit, and the other who won this year in 2022, Nina Pindam, who's working across bar associations. I'd also like to recognize, congratulations, ladies. I'd also like to recognize some of your colleagues here, Tracy, John, Marcus, and also some of our other colleagues, Tejas, Antoinette, Alistair, who are working on these issues tirelessly. So it's a pleasure to share a panel with such distinguished women leaders. And I think I should also say that it's a pleasure to be part of an initiative that is trying to change in such a fundamental way the role of lawyers in this debate. And what the IBA is doing, what the ABA, the CBA, the Brazilian Association Order of Advogados, and also the Law Society of England and Wales are doing is crucial for the work that we care about here to be successful. Mary Robinson in Warsaw, in the COP that was hosted a few years ago, it's become a bit of a blur. I was on day 9 of a hunger strike, along with about a quarter of the COP. But she said climate change is the justice challenge of our century. And she was right. And if that's not a call to lawyers, I don't know what is. Just transitions, systems change, this is our job. This is what we signed up for when we decided to go to law school. And we have a world economy that unfortunately was set up to go in the wrong direction. We have societies that have followed that economy and become unsustainable. We have a duty to protect and restore ecosystems that we have degraded. And that work is only just beginning. We were successful in ending slavery and torture, although more work needs to be done. We are starting to be successful in securing equality of women, ladies. Climate change and the Sustainable Development Goals is that next challenge, and it's existential. We have to be able to scale up fast enough. And law and governance can make a crucial contribution. And law can help or hinder. Law can foster or frustrate. We haven't always been on the side of the angels in this one as lawyers. So we need to start by implementing the Paris Agreement. According to our research in Cambridge, 169 of 186 nationally determined contributions under the Paris Agreement are highlighting the need for legal and institutional reform in order to just achieve their basic initial targets, okay? But where's the legal capacity going to come from for that? Canada, frankly, we probably have now 20 climate lawyers. Half of them are my former students. There's so much work to be done here. Very few law schools, very few judicial institutes, hardly any bar associations yet are doing this work. But when we called for interest for Climate Law and Governance Day that took place this Friday, a few COPs ago, we had 1,200 people register. And many of them were those young people that my colleague here was speaking about. And here, Climate Law and Governance Day yesterday, we had 1,400 registering, including especially from North Africa and Egypt. This work is crucial, and it is growing. And thank goodness, it's about time. So what are the main themes here? Well, obviously, yes, here in the COP, I can say international law still has a massive role to play. Operationalizing the Paris Agreement, not just market and non-market mechanisms, but also transparency frameworks. Our Implementation and Compliance Committee, loss and damage that they're right now debating over in the conference center, how the global stocktake is going to be reflected in the rules, how the sustainable development mechanism is going to be truly transparent and able to shift the direction of investment that we need. But alongside, there are three other areas that are crucially important. My colleagues have referred to them in part. First, obviously, the law and governance tools for high ambition implementation, those net zero laws across all sectors, and the work of the tort lawyers, the work of the contract lawyers, the work of the commercial lawyers, the work of people like Nina and Wendy, to actually put this into the contract and enforce it when it comes to them as arbitrators. At the same time, there's an incredible push for climate justice and resilience. And there's climate litigation taking place all over the world by incredibly brave and under threat lawyers who are trying to defend their clients and call for justice. And alongside, we need those net zero legal frameworks to enable climate neutral investment in finance. Bringing all of this work together is part of what we could do together. What the day tries to do is simply to inspire and optimize legal and institutional reforms for achieving those NDCs, to profile and share innovative international, national, and local legal challenges, mechanisms, and solutions, to catalyze knowledge exchange, co-generating new scholarship and research in this field, and to strengthen capacity, collaboration, and partnership. And I'm going to end on that point in particular because those partnerships are crucial. We have been calling, I personally in 2008 addressed the International Bar Association and asked everyone to think of themselves as a climate lawyer. We have been calling for those partners, and they're answering. Lara, what you're doing is answering that call, and we are so happy to see you. What we need is guidance for the law associations. What we need is education, continuing legal education that will be able to transform the practices of those lawyers who are there now but never took climate law in law school. How could they? It didn't exist as a course for them. That was our failing as law professors. But also building those career paths so that the young lawyers can see that if they go into tax law, they could be working on carbon taxes. If they go into contract law, they could be reflecting the net zero contribution of a company in its letters of engagement for external counsel, or in the supply chains and Scope 3 emissions of the companies. And we especially need outreach to other bar associations. The work that Nina and others have been doing, the work that you have been doing is crucial. So I'm going to end with 2 points. First is that law hasn't always been the good guy in the room here, and general counsels still aren't always. We have to be very honest about that. Judges still aren't. Lawmakers and parliamentarians, many of whom have a law background, aren't. Law can be a sword on climate change, but it could also be a shield. And it could be shielding the most vulnerable, and it could be shielding the people who are hurt worse and hurt first by that sea level rise, by those extreme weather events, by the floods, the fires, the famines that are coming. And in the end, as lawyers, law could probably be a pen. But if law is our pen, it had better be one of Malala Yousafzai's pens, when she said one child, one teacher, one book, and one pen can change the world. So to me, maybe that's my challenge for lawyers, the one that the IBA and my Law Society colleagues across the panel are taking up. You know, let's use our pens, because otherwise they just basically become an hourglass and time is running out. Thank you.
You can see why I'm a huge fan. Thank you so much. From what you've just said, I'm reminded of my time. I did a year with a judge back in Australia, and he sat in a special sitting once to a room full of silks that were being made up as Queen's Counsel, as it then was. Obviously now it's King's Counsel. But His Honour said that lawyers must defend the integrity and the independence of the judiciary as they execute their functions as arbiter of disputes, and the role of law depends on it. Because courts are there to ventilate issues in society and place them in an arena that, you know, if the rule of law is healthy, is a rational, reasonable, impartial one. But if the rule of law is not respected, lawyers and judges are needed more than ever to uphold those duties in balancing the scales of justice and to feed the necessary medicine in. And to me, it's common sense. Best available science is what leads us. And I know that we've got about half an hour left. I've got a few questions to the panel, but if there are people in the room that have questions for us. Oh, already one. Awesome. I think, two. Awesome. Three. Okay, I feel like I'm at an auction. All right. Let's take questions from the audience, because that's what we're there for. So if that could be facilitated. Or... Yeah, or project. Thank you. And if you could just introduce yourself actually and say what jurisdiction you're from, that would be awesome too. Is it possible to get a microphone so that also people at the recording can hear? Yes, it is. Thank you.
Thanks. Great panel. My name is Paul Holtus. I'm the president and CEO of the World Ocean Council. This is the global blue economy business and investment organization. And so as part of our work in bringing the business community together to work on ocean sustainability, and a lot of that's climate related, we are developing and have been working in fits and starts to get a legal ocean sustainability legal community of practice together. The issues are many and varied, and some have come up regarding sea level rise and extreme weather events, but just a few key examples. We're not advancing the use of the ocean for renewable energy as well as we could be as a society, because we've got different industries fighting with each other and sometimes ending up in court, and so offshore wind is not getting deployed. So we're losing time in solving our energy transition challenges. Another key one, just to give a couple examples, and then I'll get to my quick question. The biggest carbon sink we have in the world is, I hope you all know, the ocean. And where we're going to be able to sequester carbon most is in the ocean. There are enormous legal issues coming up as the businesses that we work with work to get out there and sequester carbon in the ocean. So my question is, how can we best, we've got a network of some legal, we've got some companies that are members of the World Ocean Council and a pretty good network, but we want to reach out much more broadly to invite, maybe through bar associations, those that are out there in the legal community that for professional and or personal reasons, there's a lot of sailors and divers and surfers out there that are lawyers that would want to engage in this. We need a global legal sustainability community of practice, and really interested to see how we can best develop that in relation to climate and other ocean change issues. Thanks.
I think Marie-Claire would like to take that one. Shall we? Yeah. Let's take the other questions first so we can start ruminating. Yeah. Oh, yeah. So if you could perhaps hand all the way up. Okay, we've got 4 questions. So shall we just take them all and then knock them off one by one? Okay, great.
Thank you for this all information. My name is Ahmed Al-Saidi. I am the only Egyptian environmental lawyer. And I would like to ask the panel about one thing. what is the one recommendation? I would like to know one recommendation for everybody in the stage about Egyptian environmental lawyer, or any environmental lawyer in north of Africa or Africa also. Thank you.
Okay, thank you. If we could hear the next question.
Hi, I'm Tammy Ganot. I'm from Israel. I work in an environmental advocacy NGO, and we're a small country, but I think per capita, lawyers per capita, we're one of the highest ratings. So, but my question is, and really, the panel, you are all inspiring, you really are. And my question is, what advice would you give to get a bar association that is not very climate or environment oriented and does not see it as its role, how to get them moving on the issue, because that's a big challenge for us. Also, I would love to hear from your experience as to, because one of the challenges we have as lawyers is that we are bound by law. And with lack of law and with lack of constitutional claims or issues, it's very hard to operate and protect. This is what we do. We try to find a way, but you have a lot of experience on the panel, and I'd love to hear that. Thanks.
Thank you.
Hello, my name is Delta Murner. I am the lead scientist. I run the Science Hub for Climate Litigation at the Union of Concerned Scientists based in the US. So in the beginning, some of your opening remarks talked about scientific literacy and the importance of that. So I'm curious how you're gaining your scientific literacy, if there are gaps in this education, and particularly if there is space for partnership or collaboration, what that looks like. This is a gap that we're trying to fill, if there are there. And then I'm also curious how you're networking with scientific experts, what that process actually looks like, so we can start to work better together as a scientific community with the legal community and close some of those gaps. So excited to hear that.
Thank you. And we have one final, two. Okay, these are oh my goodness. Okay, we've got 3 more. We're going to have to cap this. I mean, do we take them all and... We do a second round. Okay, I saw you. Okay, and that's it. 3 more questions and that's it. And we're going to try and answer them all, but if we can't, let's email and switch cards.
Yeah, thank you. I'm Eric Kasongo from DRC. I am a legal researcher at CISDL, but also an attorney at ILO. So, in your introduction, you say that Mr. John Kerry said that all lawyers now are climate lawyers. So that's a good statement and very ambitious statement. But the reality is lawyers, bar association are private sector. And private sector work for money first. So how do you think that we can shift, like to bring, as someone said here, more lawyers to actually what it is like human right issues? So for me, that's one of the big challenges. Thanks.
Thank you. I'm sorry, we can't keep taking questions, but I think we had one at the front from the man in the suit, and then one at the back from the lady, and then I think we're going to have to cap it at that to get cracking on the answers.
Thank you. Marcus Gehring from the University of Cambridge. Of course, there is a role, as Marie-Claire alluded to, for law faculties to play in climate law and governance. And I was wondering where you see that role developing. And second, there's a growing debate, at least in the United Kingdom, about the ethics, the morals of advising fossil fuel companies to become richer and to the detriment of the global climate. What are your takes on the ethical dimension of advising fossil fuel industries?
Thank you. Final question up the back.
Hi, thank you so much for the panel. I'm from Manitoba in Canada, and I'm an environmental regulator, so I work for government there. My question is more around that environmental regulator role, and I'm just wondering if you have any thoughts around what environmental regulators should be thinking of. I sort of see us as sort of the implementers of climate change policy, and we often don't look at our regulatory laws as it relates to climate change and sort of what we should be thinking about. Obviously, Indigenous rights-based approach and integration is definitely something that we take very seriously in Manitoba and across Canada. But I'm just wondering in terms of other things we should be thinking about to support climate change.
Thank you very much. So in terms of how to tackle this, just give us 1 second to divide and conquer. Yeah, I see a few as well. How to engage, OIB. Is there one you feel strongly about? Regulatory? Awesome. Okay, that's what I thought. Okay, I think we're going to kick off. This is the plan of attack. You'll tackle the first one on advancing oceans legal issues there. In terms of number 2, your question about recommendations on things to do for environmental lawyers, Letícia is going to tackle that. Your question from Israel on how to get bars engaged. Letitia's going to take that one as well. Number 4, emerging scientific literacy collaboration. I'm going to tackle that, if that's okay. Yeah, and in terms of private sector work and how to get them moving towards human rights issues. Yep, okay, very clear. Although I'm happy to comment on that if you want to do Marcus's question on legal faculties, because I don't come from one, so. Climate conscious lawyering, yeah. Well, I'll tackle with the ethical one. Perfect. And then environmental regulator. That's all you. So, number 1, off you go.
And what I'm going to actually do is blend a couple of your questions and do my best to answer. First, in terms of oceans, we're looking at the classic tragedy of the commons, just like we are with the stable atmosphere, the stable climate system that we all need, and we're all degenerating. And so I suppose the first place that I would hope to be able to point you is that the International Law Association worked for 7 years together to put together guidelines based on existing treaty law on the role of international law in the sustainable management of natural resources. And the oceans was front and center, I think led by their delegate from your country, if I'm not mistaken. And they looked at offshore energy and ways to be able to regulate it and to encourage and incentivize it. They also looked at the carbon sinks and the blue economy and blue bonds. And there is so much still to do there. Even just the lawyers that are needed to help make sure that marine protected areas are put together properly, all the way to the much more complex legal instruments that are being adopted in the British Virgin Islands, for example, my colleagues tell me, or the Seychelles. So what I would say is let's look first at those guidelines because they can help. They've done a bunch of work that we can build on. And then let's whip up the people you need to make that work happen. Otherwise, we really are going to see the same thing happening to the oceans, which we do, as is happening to our global climate system. In terms of climate literacy and legal communities and engaging them, and I think actually part of Eric's question, and he's working at the most difficult conditions in the Democratic Republic of Congo, and we salute you, especially the court cases you've been winning on behalf of forest dwellers. Yes, they're private sector, they work for money. They're also people committed to justice. They went into law school for a reason. We got to get them while they're young. And that's where I pull in, of course, Marcus's question. Because if in the law schools we get a little bit better at recognizing the importance of this issue, if in the law schools we take up the same challenge that our colleagues took up when they struggled to end slavery, law schools weren't neutral on that one. I've seen the bullet holes on their walls, including in your country, sir, in Kisangani. So if we can, not just as teachers, but also as student associations, already begin to build that interest and feed it and encourage it in our students, I think we'll find that they don't forget their values when they get to the door of their law firm. And they start asking those nasty questions that Roger was talking about. And thank goodness they do. And then I'm going to turn over to my colleague to answer the question about ethics and climate conscious lawyering.
Right now, okay. And regulators, that's going to be Selina. But in terms of ethics, and I just want to preface this by saying I've practiced for a few years. I'm young. I don't have like an entire career behind me, but from what I've seen and certainly from what the science suggests, you breach your ethical obligations if you don't act in a client's best interests, and that comes from properly conceptualizing risk, leaving opinions at the door and looking at things in a factual manner. And if we do that with the correct understanding of science, and we do that with understanding, well, financial markets and how things flow, that's really our Northern Star, I think. And at the end of the day, to act ethically is to do the thing that makes the most sense based on all the information you have available to you. And I question whether we're doing that all the time. And, this comes from a perspective of being in commercial practice. I saw a lot of really wonderful people there, really doing a lot of great and hard work. So I would hate to think that the commercial sector is demonized, because that wouldn't be fair to the lawyers that I've seen who are doing amazing work. But as I said before about the Nuremberg case in Germany, it's about keeping up with climate litigation. It's about understanding how laws shift very swiftly in this space, particularly with emissions reduction. And it's about acknowledging that emissions reduction is inevitable, it is necessary, but also keeping to the boundaries of our profession. And for example, the fact that the Bar Council in England and Wales requires barristers to promote fearlessly and by all proper and lawful means a client's best interests, and to do so without regard to their own. I say proper and lawful. Those things change over time. Those words change over time, and we need to address that. So that would be the point on ethics. Now, I think we're up to a question. I think we confused maybe some of the two to Letícia about a question from our Egyptian colleague in the back about...
Mine is how to get engaged.
Yeah, but they're interrelated. I think your question, sir, was about how the Egyptian environmental lawyers can better engage with this issue. Is nodding? Yep. And then your question from Israel was about how to get bar associations to engage. And to me, those things are interlinked, because bar associations are just representations of lawyers. So,
yep. So I really wanted to get this question, because I think OAB is an example of how this can happen. I was here last COP26 in Glasgow, representing OAB, and then we had the chance to set a meeting with ABA, the American Bar Association, the International Bar Association, Law Society of England and Wales. And because of this meeting, we started to work on this project, and I was in touch with what all the other bar associations were already doing it. And I was able to bring this back to the Brazilian Bar Association, which we have already committees in respect to climate, but we didn't have any recommendation, any resolution specifically about this. And I was able to work with my committee at the time, because I was the president of the Special Committee for Defense of Sustainable Development. So I was able to work with what all the other bars that I mentioned here have done it. We are always in close contact with them and exactly collaborating with each other. So, of course, that all what they have done doesn't really necessarily it's the same that we should do in our jurisdiction. We are different jurisdictions, we have different realities, but it was a very important start where I was able to get all the points that would be necessary, add also other points that are necessary for the Brazilian Bar Association, and I was able to draft something, and we are like in very ahead and in a final draft to finally have something for our recommendation for our lawyers. So that would be an amazing step because we have 1.2 million lawyers. So what I was gonna say that it's the most important for all of you that are here is that, and I wanted to say that from the beginning, is that we are gonna continue working jointly as bar associations, exchanging ideas, and we want to welcome the ones that would like to exchange and have this kind of conversation throughout the year to reach out to us. Because as a group we can always help each other to build the best practice at each one's jurisdiction. So that's what I wanted to say.
Okay, I just wanted to build on Lara and Leticia's points. First on the ethics. I actually started off life as an oil and gas lawyer, as a young lawyer, and I would write about climate change. So I was in Calgary, which is the headquarters of our oil and gas sector in Canada. I would write about articles and blogs about climate change. And my goal was always to educate clients because, I think as Lara said, if it makes sense, it makes business sense, right? The truth is, of course, it is about profit and shareholder returns, but at the same time it also makes business sense. So my goal has always been to educate clients, and I've been very fortunate to work with clients who are aware of these issues. So we talk about the risks, we talk about opportunities as well in the space, and by doing that they can make informed business decisions and also incorporate climate change considerations, carbon pricing into their business modeling and planning. So I think that is somewhere we can have an impact. In terms of the sort of bar associations sort of going from private and to the public interest, our Canadian Bar Association, we have advocates for both public and private sectors. So we represent public interests, and I think we have different section groups. So we have an Aboriginal section that deals a lot with a lot of reconciliation and justice issues. We are only just getting started on the discussions around climate justice. And because we have such a very sort of diverse resource-based economy, there's a lot of consideration that needs to kind of go into how we frame these issues. And I think one of the things that I've found just from my own personal perspective is that lawyers may not understand what climate justice is, what it requires them to do. And so there's maybe uncertainty around that. So it's an uncertainty around sort of support for these types of initiatives. So I think that we can frame it. A lot of us are already practicing sort of climate in our, whether we are securities lawyers and advising on disclosure, or in the public sector, working on net zero initiatives, or commercial lawyers working on carbon, emissions trading agreements. So we all have, incorporating these types of, considerations into our daily work. And it's also, I think we need to frame it as, these are actually already part of our obligations, to work in the public trust, and we just frame it, and we just need to provide some clarity and direction, perhaps, that provides that to help shift us to the climate justice, frame of mind. And my very last question I want to address, of course, the my colleague from Manitoba. Yeah, I think we're pretty good at this point, at least in BC and I think in Manitoba, and some other provinces, at incorporating the reconciliation piece around looking at legislation. I think from my experience, there's probably two areas where I think my clients would be happy to see regulators to be more proactive, and that's the regulatory gaps for new technologies. So for example, in British Columbia, we have quite a lot of companies that are looking to invest in green hydrogen, so producing hydrogen from biomass, forestry waste, for example. Or to do other types of work around clean fuel regulations, so creating credits under sort of low carbon fuels such as synthetic fuels that are created from sources other than fossil fuels. But there's a regulatory gap. There's actually no legislation that deals with it, so it makes it very hard for companies to kind of find financing and investment because there's no regulatory certainty. There are certain aspects of these types of projects that are regulated, but the actual, we need to help bridge that gap between sort of government regulation and sort of business interests. That's one area. The second area, which I think we see a lot of work that needs to be done, is around cumulative effects. So cumulative effects in Canada, because we do have certain areas around the country that have a lot of mining projects or oil and gas projects, and that's having impacts on First Nation communities. And it's very hard for companies because they're just working on the one project to actually have considerations of other projects around them. So there's a call, more opportunities perhaps for information sharing. Regulators have some of that information that they could perhaps put into a regulatory database that's open to all. So those are the types of things in terms of, I guess, sort of more technical issues for project developers that would be important.
Thank you so much. And I might just pick up on in terms of the question about regulators. I mean, I can only talk about what I know about. And in Australia, there was a case in August 2021. I did a write-up of it, so we can talk later if you want, where the Environment Protection Authority was sued for failing to develop environmental quality objectives, guidelines and policies to ensure environment protection from climate change. And it was because of their statutory duty under the Protection of the Environment Administration Act. So the Bushfire Survivors for Climate Action Incorporated basically said, you are empowered and tasked with the role of protecting the environment, and we don't think you're doing enough to do that. And the case, as I said, was handed down in August 2021, and the court found that there was a duty that the EPA owed to develop environmental quality objectives. And although in its defence, the EPA had listed out all the policies it already had, the judge found that those weren't enough. He didn't go so far as to say what they should be, but he gave the EPA 6 months to fill the gap. So that's just one example of perhaps where there's a suggested hole, the law can be used to fill it. And in terms of in human rights lawyering, I also wanted to pick up on what Selina said. I also come from a commercial law background. I practice in environment and planning, but that includes mining and Aboriginal heritage law in Australia. And I love my firm. I have a really good relation with them still, and my mentors there are people that will be friends for the rest of my life. But you're right, there are business objectives to be made, and a business case needs to be made for all things. But that can mean a lot of things, and it's about proper conception of risk, and that includes reputational risk, harm to people. And I think in the 21st century, and again, I'm only 29 years old, so I haven't practiced law all that long, but it seems like that has shifted, and it will continue to shift. And there are a lot of lawyers that want to do the right thing in firms, and please don't underestimate that, because there are them. I mean, we are them, and I have hope that proper conception of risk can really change the game. And clients, at the end of the day, want to be informed, right? Clients are wisening up, and clients want to know about climate litigation. They want to know about ESG. They want to know about how to best, turn their buck. So, yeah, I'm hopeful. And on that, we have... Yeah, sure. So with 5 minutes left, I'm going to, unless we have any further comments from the panelists, I'm going to flick over to Marie-Claire to close it out. And I just wanted to say, before I hand over the mic, thank you to everyone that's listened. Thank you in particular to my co-hosts. I feel like in the last few months and year, we've built something really wonderful, and I'm just keen to see where it goes so that we can assist our profession in conceptualizing risk and getting climate literate. Thanks.
Thank you very much, Lara, and also Letícia, for the work you're doing, and Selina, a very new friend, for the work you're doing as well. Just to flag up, tomorrow there is actually a climate law and governance specialization course being taught online for anyone who wishes to register. And there's free registration for anyone who needs it. So please do Google Climate Law and Governance Specialization course. It'll pop up right away. It's taught in the concept of in the context of the COP every year. And I'm very, very pleased that already 400 people have registered, but there's space for more. We have this pledge we have to make to 6,000 from 600 guesstimate at the moment. And speaking of that, there is actually a climate law and governance registry that has been set up by my colleagues who are sitting right there. And again, just Google Climate Law and Governance Registry and you'll get it. If you're already practicing in this area, please sign up on the registry so that you can be counted as part of the pledge. We need every single one of you. And then finally, yes, here in the Blue Zone on Thursday at 11:30, together with colleagues from all different regions of the world, from institutions that work very, very closely on climate law and governance. There will be a second side event on law called Strengthening Legal Tools and Capacity for Climate Justice and Resilience. It'll actually just be in the Akhenaten building, across the way. And I would love to see everyone there at 11:30 on Thursday, because it is going to be a chance to talk about some of the most ignored areas of law in this area, which is, of course, adaptation, which is, of course, resilience, and which is, of course, the climate justice on the ground, with some community organizations who are doing this work. So I hope to see you tomorrow online on the course, and if not, yes, there's a certificate from the course, so do sign up. And if not, I hope to see you on Thursday in the side event where we report back from Climate Law and Governance Day and more. And we have a colleague who has something else to add.
Yeah, I think we've got a comment from a member of the audience.
Hi, thanks. I just wanted to flag up a couple of other law-related events that are popping up over the next few days. So one is in the Innovation Zone, and it's being hosted by the Futures Lab. And it's called Reconfiguring the Law to Align with the Science, and that is going to be hosted by Gonzalo Munoz, the former high-level climate champion. So that's on Wednesday at 1 p.m. And then on Thursday, also in the Akhenaten room at 3 p.m., we have our organization, the Stop Ecocide Foundation, will be co-hosting, along with the Republic of Vanuatu and Planet Amazon, an event called Curbing Crisis and Enabling Implementation, the Role of Criminal Law, which will be addressing the growing impetus behind an international initiative to criminalize the worst harms to nature, hopefully to provide all of you lawyers with a very strong tool for dealing with damage to the environment. So I hope you could all make those events as well. Thank you very much.
Thank you very much. And I just wanted to finish off actually by apologising. We didn't fully answer the question about scientific collaboration. I just want to quickly say, in Australia, there's a growing, I guess, sphere of expert evidence called event attribution science, which has been used in the last few years. You're nodding, you know that, yep. And that's something that lawyers are having to grapple with, lawyers that aren't scientists. So that's just one example of where we've seen one period of expert evidence that has appeared, which all lawyers will have to grapple with. And I'd love to connect with you to talk about how to increase capacity, because as I said, it's also about education and climate literacy, so that, you know, all lawyers are armed with the ability to do that, as we are with other forms of expert evidence, like accounting, which, you know, lawyers use regularly. So thanks very much, everyone. Cheers.
Hello, testing, hello, hello.